Welcome to those who are already logged on. We'll get started right at 2. Thank you. Welcome, everyone. My name is Kristen O'Neill. I'm the Deputy Director and Counsel for the New York State Committee on Open Government. This afternoon, we'll be talking about the New York State Open Meetings Law. For some of you, it will be an introduction to the Open Meetings Law, and for many of you, it will probably be a refresher and update on the statute. Some of you are still filtering in a little bit, but we wanted to get started right at 2 o'clock. On your screen right now, you're looking at the Committee on Open Government's website. I did want to show you a few things about our website before I move into my PowerPoint presentation. A little bit of background too. This program is being recorded and it's going to be posted on our website. I'm going to show you where on our website it's being posted. So if you, this is the top of our screen. If you scroll down a little bit, you see this section that says I would like to. There's this lower right-hand corner box that says View Training Materials and Recordings. Click on that box. Here you'll see there's these FOIL training materials, OML information session. Actually, I should say training materials, but anyway, it doesn't matter. You click on those, you're going to get PDF copies of my PowerPoints. Click on this box right here. It's going to bring you to my YouTube page. It's not, luckily not, hopefully not pictures of me, but if you scroll down, the farther down you scroll, the more recent the programs are. It has been a little while since I've done my programs, unfortunately. I think the more recent program is from September of last year. It's basically just recordings of the more recent information sessions that I've done. So when hopefully by the end of this week, a recording of this program and this morning's Freedom of Information Law program will be posted on this page. Let's see, let's get rid of you. I don't want you up here. Get rid of you. Come on, shrink away, shrink away. Sorry, it doesn't want to shrink on me. Oh, come on. That's not what I want. I want you to shrink, shrink, shrink. Sorry, it didn't want to shrink on me. Okay. On this page, you'll see on this menu, there's a copy of the text of the statute, the regulations, advisory opinions that are indexed alphabetically by key phrase. They're searchable. Same goes for the open meetings law. There's our text, our advisory opinions. Here, you can find information when we're having meetings of the Committee on Open Government. News, there's about us, about the committee members, our executive director. There's a contact us page with our phone number, our email address, our mailing address. On the main page, when anything new and exciting happens in the world of open government, we try to get that information up here. We're going to talk about the extraordinary circumstances video conferencing provision that was passed 2 years ago. That was set to expire on July 1st, 2024, but was recently extended for another 2 years during this past budget session. So you'll see here, there's a little section here about that extension. So I'm going to close out the sharing to our website and go back to, go to share content, PowerPoint. There we go. Shrink that out so it's not blocking the screen. Yes, I want to hide the window. Awesome. Here's my contact information. We're a small office, an office of 5. So if you have a question about the Freedom of Information Law, the Open Meetings Law, just give our office a call or shoot an email. You can just ask to speak with an attorney, or if you send an email to that address, the first attorney in our office has an opportunity to do so. It's going to get back to you. And there's our website again. It's opengovernment.ny.gov. I just showed you what our lovely our website looks like. Open Meetings Law is codified in Public Officers Law Article 7. It was passed in 1976, and its legislative intent stated that it is essential that public business be performed in an open and public manner, and that citizens be fully aware of and be able to observe the performance of public officials. Citizens have the right to attend and listen to the deliberations and decisions that go into the making of public policy. Forgot to mention that as we're going along, I don't really have the ability to multitask that well when I'm doing these programs. If you have questions about what I'm talking about, you're welcome to put them in the chat feature. It's just that I'm not going to be able to answer them as we go along because I'm not that good about multitasking. But feel free to put them in the chat feature as we go along, and then I'll try to cover them in the end when I'm done. I'll go through the chat feature and answer all of your questions in the end. And then when I'm done, if you still have questions, you're welcome to type them into the chat feature. The Open Meetings Law governs the conduct of meetings of public bodies. That's the term used by the statute, public bodies. A public body is an entity for which a quorum, as I mentioned, someone just asked if you can get a copy of the presentation deck. If you remember from when I was just talking a few minutes ago, these slides are available on our website. An entity for which a quorum is required in order to conduct public business, which consists of 2 or more members performing a governmental function for the state, or for an agency or department thereof. For a public corporation is defined in Section 66 of the General Construction Law. Or a committee or subcommittee or other similar body consisting of members of such public body. So, for example, if you have a 15-member county legislature and you appoint 5 of those individuals to serve on a committee, that 5-member committee now has become its own public body. In addition to those sort of traditional public bodies that you think of, there are other types of entities that have been either created or appointed to perform a necessary function in the decision-making process, in the governmental decision-making process. For a quorum, also where a quorum is required to conduct public business and consists of 2 or more members. So there are entities other than that traditional, we think of We think of county legislatures and city councils and town boards and village boards and school boards, but there's other entities. There's library boards and sewer districts, and there's, for example, there's the entity out in Western New York that was created. There were some questions in the media about it's called the 514 Commission, and it was created by the governor and the mayor of Buffalo. They were given the authority and the ability to take funds that were set aside by the government to choose an artist and to choose a memorial that was going to be built in honor of the victims of the tragedy of the top shooting out in Western New York. So they were given that authority. They were the final decision makers as to who was going to be able to build that memorial, and they were going to be able to choose how that money was spent. Because they were the final decision making authority, they had that final decision making authority. They were a public body, so it's not the type of traditional public body that you think of. But they served a necessary function in the decision-making process. What the legislature has clarified is that merely being purely advisory, an entity that merely provides advice and does not require further action by a state or municipal body, is not enough to bring them into the realm of being a public body. Whenever 3 or more public officers are given any power or authority, or 3 or more persons are charged with any public duty to be performed or exercised by them jointly, or as a board or similar body, a majority of the whole number of those individuals, gathered together in the presence of each other or through the use of video conferencing, shall constitute a quorum. Not less than a majority of this whole number may perform and exercise such power, authority, or duty. For the purposes of this provision, the words whole number shall mean the total number which the body would have if there were no vacancies and were none of the persons or officers disqualified from acting. So, for example, the Committee on Open Government at full strength is supposed to have 11 members. For a while, for a good stretch of time, we were missing 2. We were down 2 members. We only had 9 people for a good stretch of time. But it didn't matter. Our quorum was still 6. It didn't matter that we were down 2 members. Our quorum was still 6, even though we were down to 9 members. We still needed 6 people to show up to every meeting to even get that meeting started. We had no authority to have a meeting. We had no authority to act as the Committee on Open Government unless we could get 6 people to even show up to that meeting. We had no authority to act as the Committee on Open Government without having 6 people to show up, and we had no authority to pass any resolution or motion unless we could get 6 people to vote in favor of a motion or resolution. Two years ago, during budget season, Governor Hochul signed Chapter 56 of the laws of 2022, and included in this budget bill was an amendment to the open meetings law to expand the use of video conferencing by public bodies to conduct open meetings, but only under extraordinary circumstances. This provision was just recently extended in the 24-25 state budget and will be in effect through July 1st, 2026, unless extended by the legislature again. This new provision was not meant to change or curtail what has always been permitted or required of public bodies in relation to compliance with the open meetings law. Public bodies may continue to operate now as they did before the onset of the pandemic in early 2020, when the in-person aspects of the open meetings law were first suspended. If you're permitted to do it before the pandemic in relation to video conferencing, this law does not change that. So what I mean by that is, even before the pandemic, public bodies were allowed to take advantage of video conferencing technology in order to conduct their meetings. Committee on Open Government is a good example. So we're a statewide body, 11 members, and we have people living all over the state of New York. In order to try to make things a little easier on our members, we used to set up our meetings. We were administratively supported by the Department of State. So we would have our meetings set up in Buffalo offices, Albany offices, and New York City offices. And our members could choose to attend at any one of those 3 locations. When we sent out our meeting notices, the meeting notices would state that our members would be attending from one of those 3 locations and that the public was welcome to attend at any one of those 3 locations. Then we would connect those 3 locations through the use of video conferencing. This has all been going on for many years, pre-COVID, long time. So that's sort of the pre-COVID, and it continues to be permitted. That's something that we could do for a long time and continue to be able to do even now. What the amendment to the Open Meetings Law in 2022 allowed was the use of video conferencing. Members of a public body are now allowed to attend a meeting using video conferencing from a private location. They would be allowed to be at home or in their offices and go attend via video conferencing without having to open that location to the public. So pre-COVID, you'd have to be attending from a public location, a location where the public also was permitted to attend. Now, the member could attend from a private location, such as their home, but only under extraordinary circumstances. So we're going to talk about what those extraordinary circumstances are. If the public body is using those first type of video conferencing, there's a whole slew of requirements that need to be followed if you're going to use the extraordinary circumstances video conferencing. But if you're using that old pre-COVID way, you don't need to comply with the new requirements. So with the new extraordinary circumstances video conferencing, it's discretionary on the part of the public body. It can choose to use it, but doesn't have to. But if they choose to conduct a meeting using this, the extraordinary circumstances video conferencing, they have to ensure that a minimum number of its members are present to fulfill the public body's quorum requirements in the same physical location or locations where the public can attend. So in other words, they have to have a quorum in a public location. So here you can see that the legislature is showing a clear preference for in-person meetings. They don't want completely remote meetings. You can't have a situation where all of your members of a public body are saying, I have an extraordinary circumstance, I have an extraordinary circumstance. You have to have a quorum at an in-person location where the public can attend in person. There is an exception to that rule. If you have a member that is that has a disability that prevents or impairs their ability to attend a meeting in person, they can count towards the quorum. They can attend via video conferencing and count towards a quorum. So to let's sum that up there. So if you have members who are participating from a physical location that's been properly noticed and is open to in-person public attendance, they do count towards a quorum and they can fully participate and vote. If you are members who are video conferencing from a remote location that is not open to in-person public attendance, they do not count towards a quorum unless they meet the disability criteria. However, once you have a quorum at an open location or you meet the disability criteria, The members that are attending via extraordinary circumstances video conferencing may fully participate and vote if the quorum has otherwise been met. In order for a public body to allow for extraordinary circumstances video conferencing, the governing body of a county, city, town, or village must adopt a local law. The Senate and the Assembly had to adopt a joint resolution, and all other public bodies must adopt a resolution following a public hearing. Everyone had to have a public hearing, not just those entities that were adopting a local law. Everyone had to have a public hearing. Public body has to establish written procedures governing member and public attendance consistent with this section, and those written procedures have to be conspicuously posted on the public website. Members of the public body must be physically present at any such meeting unless the member is unable to be physically present due to extraordinary circumstances, including disability, illness, caregiving responsibility, or any other significant or unexpected factor or event which precludes the member's physical attendance at such meeting. That's how the open meetings law defines extraordinary circumstances. Except in the case of executive session, the public body shall ensure that members of the public body can be heard, seen, and identified while the meeting is being conducted, including but not limited to any motions, proposals, resolutions, and any other matter formally discussed or voted upon. During COVID, members of a public body that were attending remotely didn't have to have their cameras on. Now, cameras on all the time. If you're attending remotely, you have to be heard, seen, and identified. Meaning if you're attending remotely, cameras on, you have to have obviously volume up if you're talking, which makes sense, but also you need to like type your name in. If you're attending via Zoom or WebEx, you need to make sure you don't just have your phone number up on the screen or an email address up on the screen, you need to type your name in on the screen. Minutes of these, if you're using extraordinary circumstances, the minutes need to reflect that, which if any members attended that way. The public notice has to inform the public that extraordinary circumstances video conferencing will be used, where the public can view and or participate in the meeting, where required documents and records will be posted, and where the physical location is. If you're using this type of video conferencing, it has to be recorded, and the recordings must be posted or linked on the public website of the public body within 5 business days following the meeting, and shall remain so available for a minimum of 5 years thereafter. These recordings have to be transcribed upon request. Public body has to provide the opportunity for members of the public to view such meeting via video. So if you have members that are attending via extraordinary circumstances video conferencing, you have to allow the public to attend via video conferencing. You also need to allow the members to participate in proceedings via video conferencing in real time where public comment or participation is authorized, and ensure that video conferencing authorizes the same public participation or testimony as in-person participation or testimony. Under the open meetings law, there is no mandate for public comment. If a public body chooses not to allow public comment at all, that is within their discretion. However, if they are going to allow those individuals that show up in person to have a time set aside for public comment or public participation, and they have video conferencing, have extraordinary circumstances video conferencing for their members and therefore for the members of the public, they also need to allow those members that are participating via video conferencing a time set aside for public comment. Because there are provisions of the statute that have obligations relating to posting on a website, the law requires that all local governments have a website. There's a provision in the statute that talks about states of emergency, whether it's state or local states of emergency. If there is a state or local state of emergency that affects or impairs the ability of a public body to hold an in-person meeting, the in-person meeting requirements of the open meetings law can be suspended. Essentially, you can go back to the way things temporarily, you can go back to the way things were during COVID by having completely remote meetings during that state of emergency. So that's sort of my overview of that extraordinary circumstances video conferencing provision. Notice requirements for the open meetings law. So now we're sort of going back into the general requirements relating to the open meetings law, not specifically relating to video conferencing. The date, time, and location, and if appropriate, instructions for virtual attendance must be given prior to every meeting. To the media, this does not mean a public body has to purchase a legal notice. It just means that notice must be given to the media, must be placed in a designated physical location. And if an agency or public body has an active website, it must be posted on the website. In terms of timing, notice must be provided at least 72 hours notice prior to a meeting that has been scheduled at least 1 week in advance. For all other meetings, meaning meetings that have not been scheduled at least 1 week in advance, notice must be given to the extent practicable at a reasonable time prior to the meeting. The open meetings law doesn't state when you're allowed to have meetings with less than 72 hours notice, but the courts have weighed in on that issue, and they state that the propriety of scheduling a meeting less than a week in advance and providing less than 72 hours notice is dependent upon the actual need to do so. If no harm would be caused by waiting to discuss an issue or making a decision on an issue until you can give the full amount of notice, then that's what you should do. Again, just as a reminder, if extraordinary circumstances video conferencing is used, you must provide notice of that fact within the meeting notice. Records scheduled to be discussed. In the fall of 2021, the governor signed into law Chapter 481 of the laws of 2021, which amended Section 103E to require that records scheduled to be discussed during an open meeting must be made available to the extent practicable upon request and posted online at least 24 hours before the meeting if the agency maintains a regularly and routinely updated website and utilizes a high-speed internet connection. The obligation to make these records available to the public upon request prior to or at the meeting and to post the records on the agency or public website prior to the meeting has been in effect since February of 2012. This amendment simply placed a 24-hour minimum time frame for making those records available. So this is sort of a long-standing requirement that I don't think got as much attention as it deserved. It's been around for a long time. It's just really since the fall of 2021, it just got a 24-hour time frame for how long before a meeting those records needed to be available. So what types of records are we talking about? Specifically, the law references proposed resolutions, laws, rules, regulations, policies, or any amendments thereto. In addition, any records or portions thereof that would be available under the Freedom of Information law that are scheduled to be discussed during the open portions of the meetings. Does not apply to records discussed in executive session. Minutes. Minutes of an open meeting must include all motions, proposals, resolutions, or any other matter formally voted upon and the votes thereon. Really, the open meetings law contains fairly bare bones requirements for what must be included in minutes. Anything beyond that is at the discretion of the person preparing the minutes. So it's a record or summary of all motions, proposals, resolutions, or any other matter formally voted upon and the votes thereon. If extraordinary circumstances video conferencing is used, it must include which, if any, members participated remotely. For executive sessions, minutes of an executive session need only be prepared if the public body voted in executive session. If they only deliberated in executive session and did not vote, no separate minutes of that executive session need be prepared. If they deliberated and didn't vote at all, no minutes need to be prepared. If they deliberated and then came out and voted in an open session, no separate minutes need to be prepared. The only time they need minutes of an executive session is if they actually voted within the executive session. In terms of timing, they must be available within 2 weeks of an open session and 1 week of an executive session. Doesn't matter whether those minutes are unapproved or in draft form. Once they've been prepared and those 2 weeks has gone by, they have to be made available to the public upon request. And in the fall of 21, Governor Hochul signed into law Chapter 587 of the Laws of 21, which amended the Open Meetings Law to require agencies that maintain a website and use a high-speed internet to post meeting minutes on their website within 2 weeks of the date of the meeting, or 1 week of an executive session. The law states that for purposes of this subdivision, an unabridged video or audio recording or unabridged written transcript may be deemed to be meeting minutes. So for point of clarification, all this means is that if a public body or agency would prefer to post an unabridged video or audio recording or unabridged transcript in lieu of posting an unapproved meeting minutes, they are permitted to do so. It doesn't mean that they don't need to prepare meeting minutes. They still need to prepare meeting minutes. They still need to make meeting minutes available upon request within 2 weeks of the meeting. So it really does not change a whole lot. It just means that if for some reason they would prefer not to post unapproved meeting minutes within 2 weeks of the meeting, they can choose to post an unabridged video or audio recording or unabridged transcript in lieu of doing so. Recordings. Any meeting of a public body that is open to the public shall be open to being photographed, broadcast, webcast, or otherwise recorded and or transmitted by audio or video means. An agency is not obligated to record unless a member is participating remotely as authorized under Section 103A, which has to do with extraordinary circumstances video conferencing. An agency may establish reasonable rules to limit disruption and interference, and we have model rules available on our website relating to that, if anyone would like to look at those. Executive session. Executive session is defined in the law as a portion of an open meeting that is not open to the public. Executive session should never be prior to an open meeting. It should never be completely separate from an open meeting. It is a portion of an open meeting. In order to enter into executive session, a member of a public body must make a motion to enter into executive session. That motion must be specific enough to reflect to fellow board members and to the public that they're going into executive session for a proper purpose. They must then vote during that open session. And then if the vote passes, if the motion passes, then they can enter into executive session. So in terms of that specificity of motion, it's been a really major topic in litigation. It's been a very highly litigated issue. When entering into executive session, public bodies want to make sure, again, that they're being specific enough to reflect to public bodies that, or excuse me, to the public that they're entering in for a proper purpose. But again, they don't want to be so specific that they're defeating the purpose of the executive session. In addition, so up on the screen right now, you'll see, don't feel like you have to memorize this all. It's all right on the slides that are available available on our on the website. You don't want to, a public body should never merely parrot the language of the statute. And that's just not coming from me, that's coming from the courts. They don't want to hear, they don't want to hear public bodies just regurgitating the language of the statute is probably what the courts have said, I believe is what the courts have said. They want you to look at the language of the statute and pull the language and use it as appropriate. I'm going to give you hopefully some good examples to use. As I look here, I'm going to say the first three I've probably hardly ever seen in my going on 9 years of working with the Committee on Open Government. I don't think I've hardly ever seen that come up. Letter D comes up fairly frequently. And what I'm going to tell you is the courts want you to identify, as a public body, they want you to identify the litigation that you plan to discuss in executive session. Because what you're allowed to do is discuss litigation strategy in executive session. You're allowed to discuss, as a public body, proposed, pending, or current litigation. And the goal is to allow a public body to discuss litigation strategy. This is not to allow a public body to discuss potential litigation. It allows you to discuss actual or proposed litigation. My rule of thumb, and it's not the only possibility, but it's one of the probably most significant possibilities when you see the word proposed, is it has a notice of claim been filed. But it has to be either actual litigation or a hair's breadth away from actual litigation. I've had people say, well, we want to discuss something that's going to, we think it's going to lead to litigation. I tell them that's not what the intent is. Everything a public body does has the potential to lead to litigation. That is not what this was intended to cover. You're allowed to discuss litigation strategy relating to an actual litigation. You're allowed to discuss O'Neill versus the city of Albany. That's not really litigation. That's just my name and the city I'm sitting in right now. So that's letter D. Letter E, collective bargaining negotiations. Identify, if possible, without causing any harm, the bargaining unit that you're having the collective bargaining negotiations with. F, this is my big thing. Don't use the word personnel. That word personnel does not appear anywhere in the open meetings law, and the courts don't like it. Also, don't say we're moving into executive session to discuss the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. That's a giant mouthful, and no public body is actually discussing all of those things at once. Take the words that actually matter. If you're discussing employment applications for a particular position, say that. Say, I move to go into executive session to discuss, to review resumes for the job openings in the highway department. If it's a disciplinary matter, say, I move to go into executive session to discuss the employment history of a particular person and matters that may lead to disciplinary action against a particular person. No, you do not need to identify the person. You just use the particular language that applies to the situation that you're specifically addressing. G doesn't come up too often, maybe in civil service boards, for example, or maybe in school district situations. H might come up if your municipality is thinking about purchasing, or whatever government entity you're housed within is thinking of purchasing or selling a piece of property. Like, for example, if you're thinking of purchasing a piece of property and you want to have a conversation about how much you're willing to offer, that's a good conversation to have behind closed doors, because you don't want everyone to know how much you're willing to offer, because it would put you in a weakened bargaining position. And, vice versa, if you're trying to sell a piece of property, you don't want everyone to know how low you're willing to go, because it would put you in a weakened bargaining position. So that's letter H. So those are just some examples of maybe just using, not, again, you don't want to just regurgitate the language of the statute. You want to just try to use it to formulate plain language motions to describe why you're going into executive session. Someone just asked me while I'm here, I just saw it pop up, proposed pending our current litigation. I think I mentioned really quickly in passing. I think notice of claim is a good example of proposed litigation. If someone has received a note, if a municipality has received a notice of claim, that's the best example of proposed litigation that I can think of. In the open meetings law, there are two avenues for meeting behind closed doors. The first is executive session. The second is exemptions. If an exemption applies, the open meetings law does not. It's as if the open meetings law does not exist at all. The first exemption is judicial or quasi-judicial proceedings, except for proceedings of the Public Service Commission and zoning boards of appeals. So, for example, some boards of assessment review, some ethics boards have these quasi-judicial proceedings that are the last step they have final decision-making authority within a municipality. And it's the last step within that municipality before someone has to go to an Article 78 proceeding. They're the final decision-making authority. It's like a hearing. If that's the case, then it's an exemption from the open meetings law. Their proceedings are exempt from the requirements of the open meetings law. The second exemption are deliberations of political committees, conferences, and caucuses. Here, let's use the example of a 5-member town board where you perhaps have 3 Democrats and 2 Republicans. Those 3 Democrats represent a quorum of the town board, but if they would like to meet together as a 3-member Democratic political committee, they may, and they can talk about whatever they want. They are permitted to talk politics. They are permitted to talk about public business. They are free to talk about whatever they want, wherever they want, without notice to the public. They just can't vote. The third exemption is any matter made confidential by federal or state law. A very common example of this is when members of a public body meet with their legal representation. Like, for example, a town board is meeting with their town attorney for the purpose of requesting and receiving legal advice. Clearly, it's not just enough to have the attorney in the room. The attorney has to be playing an active role in providing legal advice. And the conversation would be covered by the attorney-client privilege, which is made confidential by the New York State Civil Practice Law and Rules. And once the attorney's active role is complete and the attorney has stopped providing legal advice, and then the board wants to then deliberate and make a decision based on the legal advice, the exemption ends. Once the attorney's active role ends, the exemption ends. And then they have to, any further deliberations would have to occur within the confines of an open meeting. So the Committee on Open Government does not have enforcement authority. Enforcement of the statute is through the initiation of a Civil Practice Law and Rules Article 78 proceeding. A successful petitioner has may receive, excuse me, my brain went blank there. The court has the authority to award costs and attorney's fees to a successful petitioner. The court has the authority to potentially invalidate actions taken by a public body at a meeting held in violation of the open meetings law, or taken at meetings held subsequently to where the action was not necessarily taken at a meeting held in violation of the open meetings law, but where previous meetings where deliberations took place were held in violation of the open meetings law. The law itself specifies that mere technical violations are not going to be enough to invalidate an action. It would have to be a more substantial violation, not just mere technical violations. Another penalty is to receive training from me. So if anyone has questions, we are an open source, we are an open resource. Anyone is welcome to contact our office by phone or by email with questions. Government employees, members of the public, media representatives. That's our phone number, it's our email address. I'm gonna shut down the sharing, and I'm gonna go to the chat feature. Just stop. And I want to open up the chat so that I can read through some of the questions that we've gotten. This over so I can read it nice and big. I need to make it nice and big because my eyesight's not that great. Someone asked about government advisory boards. Someone said, I assume government advisory boards are public bodies. So there's some factors to take into consideration, but essentially, if it's a voluntary board and that it is purely advisory, has no required statutory function, in general, the courts are going to find that they do not meet the statutory definition of a public body. If a committee created by a county legislature is comprised of committee members who are also legislators, and the number of committee members legislators meets or exceeds the quorum of the county legislature, does it constitute a meeting of the county legislature too? And the answer is yes. We've actually prepared an advisory opinion on this subject. Once you have a quorum of the larger public body, it's no longer just a committee meeting. It's a meeting of the full public body. That's why you should never have a committee that's made up of more than a quorum of the full public body. You should always have your committees made up of numbers that are smaller than a quorum of your public body. Next question is, can a member of a public body participate remotely with their address noticed if they're participating from their private home? The answer is yes. If a member of a public body, I'm assuming this question is if they're not experiencing an extraordinary circumstance. They want to participate from home, but they want to if they want to open their home to the public, they want to include their home address in the meeting notice and state that their home is a location from which the public can attend. Yes, they can do that. But I guess my question is, why are they doing it? It just seems like an odd thing to do. Why, if you live, for example, in, for example, like if you're dealing with like a county or a town or a village, if you live in a certain geographic area, why are you opening your home to the public instead of just going to where the meeting is? It seems like an odd thing to do, but in theory, yes, if you are willing to open your home to the public and include your home address in the meeting notice, and if your home is large enough to accommodate the number of people that might be interested in attending from your location and is ADA compliant, then the answer is yes, but also it has to meet those criteria. The board members attending a board meeting via teleconference. You can't do teleconference, I'll say that. It has to be video conference. And they have included the location in the notice. We do not need to record the meeting or have a transcript. Is this correct? If it's video conference and the location is in the notice and the public is welcome to attend from that location, then no, they do not have to, you do not have to record or have a transcript. That is correct. Or in terms of extraordinary circumstances, who determines at the time of the meeting if it meets the extraordinary circumstances? First of all, it should not be being decided at the time of the meeting. It should be decided well before the meeting starts, whether it's an extraordinary circumstances, and that needs to be established via the public body's policy. 24-hour time frame requirement. What happens if the public body makes an amendment to the document at the time of the meeting and is voted on at the meeting? Nothing happens. That's fine. That happens. If there are meeting space limitations, limited capacity, no second point of egress, etc., can the public body encourage the public to attend a meeting via video conference? Yes, you can encourage the public to attend a meeting via video conference, but I will state that there are requirements in the statute that all public bodies are required to make all reasonable efforts to hold their meetings in locations that can reasonably accommodate the number of individuals who wish to attend. They need to make sure that the meetings have no physical barriers or ADA compliance. I don't know, no second point of egress. That might be a health or a health and safety violation. That sounds problematic. So that might be something to look into. Limited capacity. I'm just telling you, there's certain requirements that you need to meet in the statute in terms of making sure that it has the space to accommodate the number of people. So if it has limited space limitations because the public body hasn't really made all reasonable efforts to locate a space that can accommodate everyone, then that's a problem. If you have made all reasonable efforts to find a space that can accommodate the number of people that wish to attend, then yes, you can say, hey, this is our capacity. Once we reach this capacity, we're not going to be able to accommodate more people. So please note that we also have this video conferencing option. Someone asked if it was necessary to have a motion and vote to end executive session. There's nothing in the statute that addresses that. Someone said, I thought motions were not supposed to be made during executive session, is supposed to be made after body comes out of executive session. There's nothing in the law that prohibits motions from being made during executive session, as long as you don't vote to expend public money. Someone says, why should a governing body have to discuss in public litigation which is contemplating bringing? That might be another example of proposed. Someone else says, can you give an example of proposed? That was, I think we did that. Why doesn't the executive session subject H also apply to personal property or contract negotiation? That would have to be something you'd have to bring up with the legislature. How would you characterize request to enter executive session to discuss the information of a company that has a contract with the municipality? If the company alleges that such information is proprietary and would put the company at a competitive disadvantage if discussed publicly. I don't understand the question. I mean, there are if you look at F, like, for example, let me go back to just a second. Share PowerPoint. Too far. F, can discuss the medical, financial, credit or employment history of a particular person or corporation or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. I mean, there have been arguments made that you're allowed to discuss, if we're talking about matters leading to the appointment of a particular corporation, that you can discuss proposals you've received in response to an RFP. I mean, that might be a way you can just, if you're talking about proposals you received in response to an RFP, that's matters leading to the appointment, matters leading to the appointment of a particular corporation. I'm not sure under what other circumstances you might be discussing trade secrets or, yeah. I mean, I think I might need more specifics on that particular issue. Go back to my chat feature. Chat. Where are we? Hold on. More chat. Open up again. Yeah, I would enter into executive to discuss information. Yeah, I'm not sure under what circumstances that would need to be discussed by the public body. So maybe if this comes up, if you want to have a chat, we can discuss it. When an agency consultant attends and comments remotely at a meeting, must the public also be allowed to participate remotely? No. If you need to have either an employee or a consultant attend via video conference for a specific purpose, no, you do not need to let everybody else attend via video conference. Must the records available digitally on the website prior to the meeting also be available as hard paper copy at the meeting? What it is the law says upon request must be made available upon request 24 hours prior. So would I have a couple of copies available at the meeting? Probably yes. Sometimes the chat reboots itself and goes back in time. It says the company wants exec session to discuss proprietary information. Well, the company doesn't get to decide, is what it comes to it. I mean, the public body has to comply with the open meetings law, and if the company can't, if the public body can't point to something in the open meetings law that allows them to enter into executive session, then they can't. So clearly, no, the public body does not have to honor any request to go into executive session unless they feel like they have a comfort level that they're going into executive session for a proper purpose. I think sometimes private companies, they get to go into executive session whenever they want. So they don't understand government. What are the requirements regarding allowing remote members of the public to video conference? Oh, we just talked about that quite a lot. Can the body turn off the microphones or faces of members of the public? Yes. Can members of the public hold up a sign protesting an action while the body is deliberating? You don't have to, the public body does not have to allow cameras being on for video conferencing for the members. Can the public body require pre-registration to join a video conference? No. So there we go. That is the end of the chat feature. I'd like to thank everyone for joining me today. If there are people that had follow-up questions because I didn't answer them, because I wasn't understanding the question or didn't answer as fully as you would like me to, that I'd be happy to answer questions directly. Again, thank you everyone for joining me today. And you all have a lovely afternoon and a good week. Thank you very much.